Please report my roll. This is the case of the state versus Stella-moordverhoor. The accused is present as well as in the audience.
Yes, thank you. Mr. Nell, you confirm your appearance?
May I please report, my lord, I confirm my appearance on behalf of the accused. I indeed received instructions from the accused that he do understand English and is therefore not necessary for my lord's judgment to be translated to Afrikaans.
Yes, thank you. Take down the following judgment. Mr. Zander Bijlsma, hereinafter referred to as the accused, is charged with 2 counts of murder. It's alleged that on the 26th day of May 2018, and at Stella in the district of Vryburg, he unlawfully and intentionally killed Chanel Hoog and Marna Engelbrecht by throttling them. The state alleged that these offenses were premeditated and that Section 51(1), read with Part 1 of Schedule 2 of the Criminal Law Amendment Act 105 of 1997, which carries a minimum sentence of life imprisonment, is applicable. The accused pleaded not guilty to these 2 counts and exercised his constitutionally entrenched right to silence. Several witnesses testified in this case, and documentary evidence were also presented. The evidence presented for and on behalf of the state can be summarized as follows. Both Chanel and Marna were students at Stella High School in Stella. They were roommates, staying on the first floor of the hostel. During the evening of the 25th of May 2018, they were the only two girls in the girls' section of the hostel. The school boys rugby players were in the boys' section of the hostel. Christelle Uester, the matron of the girls' hostel, testified that Chanel and Marna were supposed to travel with the boys the following morning to Koster, where the boys played rugby. The doors leading to the girls' hostel are usually locked in the evenings, but that evening it was not locked because Chanel and Marna asked her not to lock it. According to her, they said that someone would bring clothes for them that evening. That is why they asked that the hostel doors should not be locked. Uester, who stayed on the ground floor of the hostel, went to bed at approximately 2200 hours. The following morning, at about 5:30 a.m., she intended to wake Chanel and Marna up. On her way to their room, she discovered Chanel hanging at the staircase. She called Mr. Bredenkamp, who was the hostel caretaker. Marna's body was found in the bathroom on the ground floor. The police were then summoned. Captain Heeman, a member of the South African Police Services, received a telephone call on the morning of the 26th of May 2018 about the incident. He went to the scene and met Mr. Bredenkamp. He went into the hostel and he saw Chanel hanging on a rope at the staircase. Marna's body was found in the bathroom. The local Criminal Record Center personnel of the South African Police Services was contacted. Captain Heeman then handed the scene over to Constable Mabatu. Mr. Chris Saunders was also present at the scene, and some of the parents asked Mr. Saunders to assist in this case. Heeman was aware that Saunders would go to the accused, and he had no problem with it. Saunders phoned him later and informed him that he is coming with the accused. Post-mortem examinations were conducted on the bodies of Chanel and Marna by Dr. Els, a forensic pathologist. Dr. Els concluded that the cause of death of Chanel was asphyxiation due to throttling and hanging. Throttling and ligature constriction in combination. There were defense-type injuries present adjacent to the nail beds of Chanel's fingers. These injuries could have been caused when she defended herself or in an attempt to remove the rope from her neck. He opined that Chanel was most probably at first throttled until she lost consciousness, and thereafter the rope was placed around her neck and she was hanged at the railings of the staircase. According to Dr. Els, Chanel did not commit suicide. He is convinced that she was throttled and thereafter hanged. The bruises on her body are consistent with the body being lowered over the railings when she was hanged, which is also indicative of the fact that she was not willing to be hanged. Hair and blood samples, as well as vaginal swabs, were also taken and sent for forensic analysis. There were also other bruises on her body, as well as on her skull. This was as a result of blunt force trauma. The cause of death with regard to Marna was asphyxiation due to ligature application. There was a ligature mark on the neck of Marna. In Dr. Els's opinion, Marna was throttled with a strap because there was a 15 millimeter wide abraded strip or ligature mark on the left side of her neck. There were also bruises on her skull as a result of blunt force trauma. Furthermore, There were also scratches on one of her knees because she was found in a kneeling position. Admissions were made in terms of the provisions of Section 220 of the Criminal Procedure Act during the trial. It was admitted that the bodies of Chanel and Marna sustained no further injuries from the time that the incidents leading to their respective deaths occurred up until the post-mortem examinations were conducted on their bodies. Brandon Victor was a student at Stella High School during 2018, and he also stayed at the boys' section of the hostel. He and Chanel were involved in a relationship. He visited Chanel and Marna on the evening of the 25th day of May 2018. He arrived at 2300 hours 15 minutes at their room. They chatted, drank coffee, and at some stage he and Chanel also caressed each other. Chanel even pressed out pimples on his back. At some stage, Chanel's phone rang. He could see that it was the accused who was calling. He was aware that Chanel and the accused were previously in a love relationship. He told Chanel to answer the phone and put it on loudspeaker, which she did. He listened to the conversation between Chanel and the accused. The accused said that he wanted to bring clothes for Chanel. She said that the doors of the hostel are locked, but that he can give the clothes to Marna through a window on the ground floor. He then testified that when Chanel told the accused that the doors leading to the hostel are locked, the accused said that he will make a plan to open it. The accused got annoyed and very angry. He started swearing at Chanel, using vulgar language, couched in crude gynecological terms, which words need no repetition. He, inter alia, also told her that he hoped that she would be happy about what he is going to do that evening. By this, Brandon thought that the accused was threatening to kill himself and wanted to play on the emotions of Chanel, as he used to do. Chanel was very tense and upset. Brandon asked her whether he should sleep with them, but Chanel refused because she was afraid of getting into trouble at school and with the hostel parents. He then said that she could sleep in his room, which she also refused to do. He later on went to his room and made a WhatsApp call to Chanel to ascertain whether she was okay, whereafter he went to sleep. He got up the following morning between 7 and 8 a.m. in order to get ready to travel to Koster. He then saw that Chanel's phone was online during the evening, but he can't recall at what time. Whilst busy washing, Mr. Bredenkamp asked him whether he had Marna's telephone number, which he then gave to Mr. Bredenkamp. When Chanel and Marna did not show up to travel with a bus to Koster, he thought that the accused perhaps kidnapped them. That is why Mr. Bredenkamp wanted the telephone numbers of Marna. He then traveled with his teammates in the bus to Koster. He learned about the death of Chanel and Marna shortly before the rugby match started in Koster. He testified that the accused phoned on Chanel's phone on the 24th day of May 2018 and told him to leave Chanel out. There was a heated exchange of harsh words between them. Ronnie Hough, Chanel's father, testified that he received a WhatsApp photo and message from Chanel's phone. The photo was received at 3:45 a.m. on the morning of the 26th of May 2018, and a message at 4:20 a.m. He was called and informed about the incident and arrived at Stella Hostel at approximately 7 a.m. that morning. He was aware that Chanel and Brandon were in a relationship. This he knew about as far back as 3 to 4 weeks prior to the incident. According to him, Chanel would not have sent a half-naked photo of herself to him, only wearing a bra. Furthermore, the message that was sent to him is also not in the style of language used by Chanel to communicate with him. According to him, somebody else must have sent the photo and the message. Anastasia Visser is known to the accused. They were at first Facebook and WhatsApp friends. They later physically met at Bloemhof Dam during March 2015. They also agreed thereafter to meet at Herzogsville Agricultural Show. They were just friends. She knew about the relationship between the accused and Chanel. Later on, she and Chanel got to know about each other, and they were also at times together at netball matches. At one stage, Chanel told her that she wanted to terminate her relationship with the accused. During February or March 2018, the accused contacted her telephonically and resumed their communication. On the 24th of May 2018, at approximately 1800 hours, the accused phoned her. He was very angry and upset. She asked him why he was angry and upset, and he responded by saying that Chanel had moved on with her life, whereas he could not. Chanel sent inappropriate photos of herself to another boy while she was in a relationship with him. He said that he would go to Stella and does not know whether he would be able to control his temper. He also said that he is going to make the life of Chanel hell to such an extent that she will commit suicide. That he would thereafter go to Chanel's father and tell him that he, being the accused, is the cause thereof. He would also show the photos that Chanel sent to the other boy to her father. As she was busy watching a TV soapy, she then asked the accused to call her later after the soapy had ended. The accused did call her again. She did not contact Chanel to inform her what the accused said. After she learned about the incident, she sent a Facebook message to the mother of the accused, whereupon the accused's mother called her. She also tried, unsuccessfully though, to contact the accused. Captain Botha of the South African Police Services is attached to the technical division of the SAPS. He is an expert in the field of cell phone statements, data, and how cell phones work. He was asked to investigate the cellular phone contact between the accused's cell phone numbers vis-a-vis that of Chanel and Anastasia. The investigation centered around where the cell phone of the accused was in the early morning hours of the 26th of May 2018. According to him, not necessarily the nearest tower, but the one with the strongest signal will pick up the handset or device. The investigations revealed that the accused was in Stella because the Stella tower is reflected as the one that picked up the signal from the handset of the accused. The investigations further revealed that on the 24th of May 2018, there were 3 calls from the phone of the accused to that of Anastasia, to wit, at 17:55, at 18:21, and at 18:30. Furthermore, on the 26th day of May 2018, there were 6 calls from the accused to Chanel at 01:09, 01:10, 2:35, 2:36, 2:37, and 2:38 a.m. At 3 a.m., the phone of the accused was still active in Stella, and even at 3:26 a.m. At 5:01 a.m., it was in Vryburg. The accused testified in his defense, and he also called witnesses. He testified that he and Chanel were previously in a love relationship. The relationship was terminated at some stage, but they then reconciled. During the evening of the 23rd of May 2018, he phoned Chanel and they conversed for a very long time. It was agreed that he would visit her the Friday evening of the 25th of May 2018. She informed him that Brandon Victor was also interested in having a relationship with her. He then said that he would talk to Brandon, which he did. When he arrived at Stella, in front of the hostel, in the early morning hours of the 26th of May 2018, he phoned Chanel in order to come and meet him, but the phone call got cut. He phoned again. Chanel came to him and joined him in his motor vehicle, which was a van. They chatted and ultimately ended up being intimate. Later on, she went back into the hostel and he drove from Stella to Vryburg. He called her to ask if she is happy now that they have reconciled. Because the phone was cut off again, he had to call once more. Outside Vryburg, he drove to the farm Kameelfontein, where his mother resided. He stopped outside the gate to smoke, listened to music, and drank a soft drink. A Volvo truck emerged from the farm. He then drove into the farm and went to sleep at his mother's house. Later that morning, he woke up and drove to his father's farm at Lona. During the course of the morning, he received a phone call informing him that Chanel and Marna committed suicide. He was very emotional about this. His father inquired what was wrong, and he informed his father. His father then refused that he should go to Stella in such an emotional state. He denied that he told Anastasia that he was angry with Chanel because she had moved on with her life. Furthermore, that he would turn Chanel's life into hell, so much so that she would commit suicide, and that he would show the inappropriate half-naked photos of Chanel to Chanel's father. He admitted that he phoned Anastasia, but for a different reason. According to him, Anastasia sent him a WhatsApp, and he then called her 3 times. She asked him for advice as she was facing a disciplinary hearing at school. He also denied the testimony of Brandon Victor that he called Chanel, swore at her, and said that he hoped that she would be happy about what he will do that evening. In short, he denied that he killed the deceased, Chanel and Marna. Michael Dupree from C-Track, a tracking and security company, testified about the operations of C-track. He said that a tracking device is installed in a Volvo truck belonging to McDonald's Transport, operating from the farm Kameelfontein. He testified about the movements of the Volvo truck, in particular on the morning of the 26th of May 2018, and specifically at what time it left the farm Kameelfontein. This is the same farm where the mother of the accused worked and resided. According to his investigations, the truck left the farm at 4:22 a.m. Captain Mashehuane from the Forensic Science Laboratory of the South African Police Services testified with regard to the DNA samples that he received for analysis. According to him, foreign DNA was found under the nails of Chanel. This DNA does not belong to either Chanel, Marna, or the accused. It emerged during cross-examination that the seal bag numbers from the samples that he examined and analyzed differs from that recorded by Dr. Els, who took samples when he performed the post-mortem examinations on the bodies of Chanel and Marna. It is quite apparent that the samples that this witness examined is definitely not the samples taken by Dr. Els. It is clear that these samples were taken after those taken by Dr. Els. It must be that the samples were taken, let me repeat, it must be that samples were taken for a second time. Therefore, the difference in seal bag numbers. This is in brief a summary of the evidence presented in this case. It is, however, not the only evidence presented, as there were also documentary evidence presented. I will later on deal in more detail with this evidence. A trial within a trial was conducted in order to determine the admissibility of a statement made by the accused to Colonel Coughlin, and pointing out in an accompanying statement which he made to Colonel Lange. These statements were contested on the basis that they were not freely and voluntarily made, but were made under duress, and whilst the accused was not in his sound and sober senses. His rights, in particular his right to silence, were not explained to him. Furthermore, that he is not the author of what appears in these statements, as he was told by Saunders what to say. He merely repeated to Colonel Coughlin and Colonel Lange what Saunders told him to say. At the close of the trial within a trial, the court ruled these statements provisionally admissible as evidence against the accused and stated that the reasons will follow. Here follows the reasons. The state called Saunders to testify. It is common cause that Saunders travelled to the farm belonging to accused father. Upon his arrival at the farm, he met the accused, his father Monty Bylsma, and Stefans Engelbrecht, the father of the deceased, Marna Engelbrecht. Stefans was outraged about the death of his daughter and made some threats towards the accused. Saunders rescued the situation, and it was inter alia agreed between him and Monty Bylsma that he would take the accused with him in his motor vehicle, which happened to be a van, to Vryburg police station. Whilst travelling in the van, Saunders started asking the accused questions in order to probe his possible involvement in the commission of these offences. The accused was at first reluctant, but later on started to explain what he knows about these offences. unbeknown to the accused, Saunders was recording their conversation. During the trial within the trial, the actual recording was played in court, and a transcript thereof was also handed in as an exhibit. The evidence of Saunders was not presented as a confession or admission made to a private person or even private investigator, but merely to refute the allegation that Saunders told the accused what to say when making the statements to Colonel Coughlin and Colonel Lange. The admissibility of the evidence of Saunders, the authenticity of the tape recording, and correctness of the transcription thereof were not disputed. The focus during cross-examination of Saunders shifted from that he told the accused what to say when making the statement or confession to his registration as a private investigator, who actually called him and instructed him to assist in this case, whether the accused was in his sound and sober senses, etc. It is quite apparent from the tape recording and its transcription that Saunders never told the accused what to say when he made these statements. The accused related to Saunders what happened, and Saunders asked questions in clarification, which the accused answered. The accused volunteered the information, and the information did not originate from Saunders. He did so in great detail. The conversation between them was also quite extensive and lasted for a very long time. To reiterate, the evidence of Saunders was not produced as evidence relevant to the guilt of the accused, but merely to show that Saunders did not prescribe or told the accused what to say. The accused never testified that the conduct of Saunders prompted him to make these statements to Colonel Coughlin or Colonel Lange, or that it influenced him in any way to make these statements. Furthermore, it is clear that Saunders told him to tell the truth without telling him what to say. This does not equate to undue influence. Colonel Coughlin, who took down the statement or confession of the accused on the 26th day of May 2018, commenced with taking it down at 2100 hours and 9 minutes. That is 9 minutes after 9 in the evening. And it ended at 22 hours 30 after more than 1.5 hours. It was also done more than 5 hours after Saunders met with the accused on his father's farm. Colonel Coughlin testified in great detail how he went through the erroneous part of the statement, consisting of 13 type pages, with the accused, and how the accused understand all the rights, including the right to silence, explained to him. The answers provided to each of the questions were recorded, as well as the observations by Colonel Coughlin. The accused narrated to Colonel Coughlin what transpired in a 7-page handwritten document which contains a lot of detail. It is clear from the evidence of Colonel Coughlin, as well as the statement itself, that the accused never indicated to Colonel Coughlin that he was not making the statement freely and voluntarily, that he was not in his sound and sober senses, that he was under duress and being unduly influenced to make the statement, or even that he is not the author of its contents, but that he was told by Saunders what to say in it. The same applies to the pointings out and accompanying statement which the accused made to Colonel Lange the following day, being the 27th day of May 2018, which commenced at 1000 hours and ended at 1700 hours 18. The accompanying statement of the pointings out is equally detailed and consists of quite a number of handwritten pages relating in some detail the events of the 26th day of May 2018. It is quite apparent from the 24-page document that the accused was indeed apprised of all his rights, that he was not unduly influenced to make the pointings out and statement, but he did so freely and voluntarily, being in his sound and sober senses. He never said to Colonel Lange that he was told by Saunders what to say. What applies to the statement made to Colonel Coughlin applies mutatis mutandis to the statement he made to Colonel Lange. Lieutenant Colonels Masire and Captain Paul also explained the rights of the accused to him. Masire first spoke to the accused, and the accused related to him during the interview what happened. Out of disbelief of what the accused told him, Masire asked Paul to also listen the accused out. Their evidence were not presented to confirm the contents of what the accused told them, but to highlight the fact that the accused's rights were indeed explained to him, whilst in his sound and sober senses, and without any undue influence. This was done even before he could depose to the statement before Colonel Coughlin, and pointings out an accompanying statement to Colonel Lange. The accused testified during the trial within a trial. His evidence centered mainly on how Saunders told him what to say in his statement to Colonel Coughlin and Colonel Lange, and that he had taken pills which affected him. He was questioned about the contents of the statement, and he indicated sentence by sentence what information originated from Saunders and what he divulged out of his own. Firstly, the fact that some of the contents originated from him is clearly indicative of the fact that he was not telling the truth when he initially said that what is contained in these statements are what Saunders told him to say. Furthermore, the accused had great difficulty to explain that he was unduly influenced and not in his sound and sober senses when he made these statements. To reiterate, the contents of these statements are quite detailed and quite a lot for a person to cram and repeat hours and even a day after he was told by Saunders. The accused admitted on numerous occasions during cross-examination that he lied and or made mistakes. To say the least, he proved to be a very unreliable witness. It was conceded by his counsel, quite correctly I must say, that the accused was not at all a good witness. He contradicted himself materially on numerous aspects and on numerous occasions, and even contradicted what his previous counsel put to the state witnesses. He also shifted the blame to his previous counsel. Furthermore, his version is also not without improbabilities. On his own version, he, as a major, decided not to have his parents present when he made these statements, even though he was specifically asked about it by Masire and Coughlin. He emphatically said that he did not want them to be involved. This is also contained in the statement that he made to Colonel Coughlin. He later on tried to hide behind the fact that his parents were threatened by Stefans Engelbrecht. The same applies to the right to legal representation. he, as an adult, took an informed decision not to be legally represented, even though specifically informed about his right to legal representation by both Colonel Coughlin and Colonel Lange. This, despite the fact that his father arranged legal representation for him. The accused conceded that when he made the pointings out to Colonel Lange, he knew that his parents appointed a legal representative for him, but he did not see the need of using the services of a legal representative. The state witnesses who testified during the trial within the trial were truthful, honest, and reliable, unlike the accused. Their evidence are accepted by this court. The evidence of the accused is rejected insofar as it contradicts that of the state witnesses. The contents of these statements are detailed and tells a story of mixed emotions, jealousy, love, disappointment, and revenge. The statement made to Colonel Coughlin amounts to a confession. It is for the aforementioned reasons, inter alia, that the statements were ruled to be provisionally admissible as evidence against the accused. The court has now to determine whether anything in the main trial affected the admissibility of these statements in order to exclude them. Furthermore, whether the state succeeded in proving the guilt of the accused beyond any reasonable doubt. There is no onus on the accused to prove his innocence. The version of the accused need only be reasonably possibly true in order to be accepted by this court and for the accused to be given the benefit of the doubt and be acquitted. Such is the onus on the state that this court need not believe the version of the accused. Let's believe it in all its detail. It suffices that his version need only be reasonably possibly true for him to be acquitted. This court will now examine the evidence tendered by the state to determine whether there are corroboration, especially in evidence aliunde, for the contents of these statements. With regard to Chanel, in his statement to Colonel Coughlin, the accused stated that he put his arm around the neck of Chanel and throttled her until she passed out or lost consciousness. The rope that was placed around the neck was fastened to the railings of the staircase. He lowered her body over the railings so that she could hang. In his statement to Colonel Lange, the accused stated that he held Chanel from behind very tight to have the effect that she passed out or lost consciousness. As the rope was around her neck, he then slowly released her to hang. Corroboration for this is to be found in the testimony of Dr. Els, who testified that Chanel's cause of death was asphyxiation due to throttling and hanging. According to him, the deduction that he made was that she was throttled until she lost consciousness, and then the rope was put around her neck and she was hanged. The bruises on her body was, according to Dr. Els, caused by the lowering of the body over the railings, which is definitely not the case where a person hangs himself or herself. Dr. Els furthermore excluded suicide as a possibility because Chanel fought for her life. This is proven by the fact that her own DNA was discovered under her nails. She must have tried to free herself from the rope around her neck. Once again, this does not happen in a case where a person committed suicide by hanging himself or herself. With regard to Marna, the accused stated in his statement to Colonel Coughlin that Marna was on her way to the bathroom. He saw a handbag underneath the staircase and picked it up. He then followed Marna into the bathroom. She was busy washing her hands. He then throttled her. This was also repeated in the statement which he made to Colonel Lange, although he said that he cannot recall the detail of how it happened. Dr. Els concluded that the cause of death of Marna was asphyxiation due to ligature application. There was a ligature mark on the neck of Marna. In his opinion, Marna was throttled with a strap because there was a 15 millimeter wide abraded strip or ligature mark on the left side of her neck. The evidence of Dr. Els corroborated the contents of the statement which the accused made to Colonel Coughlin and Colonel Lange insofar as Marna's death is concerned. The evidence of Captain Heeman confirms and corroborated the positions and locations of the bodies of Chanel and Marna. It was also the evidence of Uester that she saw the body of Chanel hang on the railings of the staircase. Marna's body was discovered in the bathroom. So too does the evidence of Uester that she didn't hear any screams, corroborates the contents of these statements. The accused throttled both Chanel and Marna so that they could not scream. That explains why no screams was heard by Uester. He must have accosted them and throttled them unexpectedly from behind. In his statement to Colonel Lange, the accused stated that he asked Chanel whether she had sent photos to a male friend, which she confirmed. This is corroborated by the evidence of Anastasia, who testified that the accused told her that Chanel was sending photos of herself to another male friend and that he will show it to Chanel's father. This is indeed what happened, because Ronnie Hoog testified that an inappropriate photo of Chanel being half naked was sent to his phone from Chanel's phone. This too is corroboration for the contents of the accuser's statement. In his statement to Colonel Coughlin, the accused stated that he called Chanel on the evening of the 25th of May 2018. In his statement to Colonel Lange, he stated that he called Chanel around 1 a.m. in the morning of the 26th of May 2018. According to Captain Boertes, whom this court found to be an expert witness with regard to cellular phone records and operations, there were 6 calls from the phone of the accused to that of Chanel between 1:09 and 2:38 on the morning of the 26th of May 2018. Although in the statement, mention is only made of one call that the accused made to Chanel's phone, Captain Boertes' evidence serves even as corroboration and confirmation of this call. It is quite apparent from the aforementioned that there is indeed overwhelming evidence of corroboration for the contents of the statements which the accused made to Colonel Coughlin and Colonel Lange. No evidence was presented during the main trial that affected the admissibility of these statements in order for this court to exclude it as evidence against the accused. It therefore remains admissible as evidence against the accused. The other evidence presented during the trial must also be evaluated by this court. Anastasia's evidence that she and the accused knows each other and that they met are common cause, although some of the details as to where they first met differs. that they had telephonic contact is also not disputed. This is even corroborated by the evidence of their cellular phone records, as testified to by Captain Botha. According to Anastasia, the accused phoned her on the 24th of May 2018. He was very upset and angry. She asked him why he was angry and upset. He responded by saying that Chanel had moved on with her life, whereas he could not. Chanel sent inappropriate half-naked photos of herself to another boy while she was in a relationship with him. He said that he would go to Stella and does not know whether he would be able to control his temper. He also said that he is going to make the life of Chanel hell to such an extent that she will commit suicide. He would thereafter go to Chanel's father and tell him that he, being the accused, was the cause thereof. He would also show the photos that Chanel sent to the other boy to her father. As she was busy watching the TV soapy, she then asked the accused to call her later, after the soapy had ended. The accused did call her again. According to Captain Botha, the calls that the accused made to Anastasia on the 24th of May 2018 were made at 17:55, 18:21, and 18:30. This lends credence to the evidence of Anastasia that the accused called while she was watching a soapy called Seven de Laan, which is screenplayed between 1800 hours and 1800 hours 30. However, of more importance is the fact that he mentioned to Anastasia the reasons why he was angry and upset with Chanel. This is, however, denied by the accused. Whilst admitting that he and Anastasia had telephonic contact, the accused said that she phoned him to seek Whilst admitting that he and Anastasia had telephonic contact, the accused said that she phoned him to seek advice for a disciplinary hearing she was facing at her school. This Anastasia denied. These two versions are diametrically opposed and cannot both be true. According to the testimony of Brandon Victor, he was involved in a relationship with Chanel. He must be the other boy who happened to be in the life of Chanel, proving that she had moved on with her life. This was confirmed by Brandon and Chanel's father, Ronnie Hope. The profile picture on Chanel's WhatsApp status on her phone is also a photo of herself and Brandon, which corroborate this piece of evidence as testified to by Brandon. Furthermore, Anastasia said that the accused mentioned to her that Chanel sent half-naked photos of herself to another boy. Ronnie Ho, Chanel's father, testified that he received such a photo sent from the phone of Chanel to his phone. This is too much of a coincidence. How would Anastasia have known of the inappropriate half-naked photo that Chanel sent to the other boy if she wasn't told by the accused? Coincidentally, the photo was sent to Chanel's father's phone, which fits in perfectly well, I hasten to add, with the testimony of Anastasia, that the accused told her that he will show the photo to Chanel's father. Once again, I reiterate, this is too much of a coincidence. Anastasia's evidence that the accused said that he will make the life of Chanel hell to such an extent that she will commit suicide serves also as corroboration for the contents of the statements which the accused made to Colonel Coughlin and Colonel Lange, in which it is stated that Chanel committed suicide and that he only helped her. Brandon Victor's evidence that the accused phoned Chanel whilst he was with her and Marna in the room is confirmed by Captain Botha. Even the times that he phoned are corroborated. According to Brandon, he left approximately 5 minutes after the accused phoned Chanel, and it was after 100 hours in the early morning hours of the 26th of May 2018. The phone records of the accused's cellular phone confirms that he called Chanel at 1:09, 1:10, and then 4 times thereafter, as testified by Captain Botha. According to the testimony of the accused, he arrived in Stella after midnight, and he left Stella between 2 a.m. and 3 a.m. on the morning of the 26th of May 2018. The cellular phone records, according to Captain Botha, proves that he was in Stella at 300 hours 07 and even at 300 hours 26 a.m. on the morning of the 26th of May 2018. He also conceded during cross-examination that he could have been in Stella up until 3:30 a.m. that morning. But he is not sure about the time. It is clear that he was trying to get away from the fact that a photo was sent to Ronnie Ho's phone at 3:45 and the message at 4:20. The accused wanted to create the impression that Brandon could have killed Chanel and Marna, and that he, being Brandon, sent the photo and message to Chanel's father. Furthermore, that Brandon lied about the contents of the phone calls that the accused made to Chanel. As already alluded to earlier, the cell phone records, according to Captain Botha, clearly indicates that the accused called Chanel 6 times between 1:09 and 2:38 a.m. This is in sharp contrast to the evidence of the accused that he called Chanel to inform her that he was in Stella and sat and waited for approximately 10 minutes for her to arrive. On his version, the phone call was cut and he had to call again. That, according to his testimony, explains perhaps the first 2 calls at 1:09 and 1:10. The explanation proffered for the other calls at 2:35, 2:36, 2:37, and 2:38 a.m. are that when he left, he phoned Chanel to find out if she is okay. Because the phone call was again cut, he had to phone again. However, that leaves 2 calls unexplained. Brandon's testimony with regard to the contents of the conversation between the accused and Chanel fits in with the duration of one of the calls, namely 140 seconds, 2 minutes and 20 seconds. The duration of the call makes Brandon's version more probable than the version put forward by the accused, namely that he only informed Chanel of his presence and that she should come out and join him in his van. This could not have taken 2 minutes and 20 seconds. The accused's suggestion that Brandon could have killed Chanel and Marna is, to say the least, far-fetched. If at all there was a reason for Brandon to kill Chanel, then the question that begs an answer is, why did he also kill Marna? As a possible answer, it could be reasoned that Marna, being the roommate of Chanel, was at the wrong place at the wrong time. That is why he perhaps also had to get rid of her or even silence her so that she should not implicate him. Of course, it is a possibility, but in actual fact, it is highly improbable. As a possibility, too, it is too remote. The possibility that it was the accused who killed Marna is much more probable. If regard is had to the contents of the statement to Colonel Coughlin, the accused explained that Chanel told him that Marna would not approve of their reconciliation and the continuation of their relationship. Lo and behold, Marna was in the hostel, and as fate would have it, she went to the bathroom while Chanel went to put on her ski pants because it was cold. It was, after all, the 26th day of May 2018. It was during the last week of autumn and almost winter. According to the statement, he seized the opportunity and took the handbag, which has a sling or strap, followed Marna into the bathroom and throttled her with a sling or strap of the handbag. This is more probable than merely blaming Brandon. As far as Chanel is concerned, she had moved on with her life. She had Brandon, as testified to by both Brandon and Ronnie Hough, Chanel's father. This angered the accused, as he told Anastasia, because he could not move on with his life, whereas Chanel clearly moved on with hers. He was aware that Chanel sent photos of her being half naked to another boy. This too did not sit well with the accused. He told Anastasia that he would make Chanel's life hell to such an extent that she would commit suicide, and that he would then inform Chanel's father that he is the cause of Chanel's suicide, and even show him the photos. This, what he told Anastasia, fits in perfectly well with what is contained in his statement. Chanel was found hanging on the railings of the staircase, thereby creating the first impression that she committed suicide. This is exactly what the accused told Anastasia. Furthermore, the photo of Chanel was sent to the phone of Chanel's father, Ronnie Hough, again, as he told Anastasia. The accused was arrested on the day of the incident, being the 26th day of May 2018. By then he knew that he was innocent and that Brandon Victor was a possible suspect. This because of the verbal altercations he had with Brandon about Chanel. In his bail application during December 2018, he stated that he was not in any manner suggesting that Brandon was involved in the murder. This even though he suspected that Brandon was a suspect. It defies all logic that he would protect Brandon, knowing very well that Brandon was his competitor and the proverbial fly in the ointment standing in his way to reconcile with Chanel. It is only during trial, and in particular during cross-examination, that the accused insinuated that it might be Brandon and thereby implicated Brandon in the commission of these offenses. Perhaps the accused had in mind the fact that his DNA was not found on either Chanel or Marna, but that foreign DNA was found under the nails of Chanel. It is not proven to whom this foreign DNA in fact belongs. Surely, it is not proven that it belongs to Brandon. Even if it was to be proven that it belongs to Brandon, then there is a reasonable explanation for it. Chanel pressed out pimples on Brandon's back. That, in my view, is but a neutral factor. The state alleged that the murders were premeditated and pre-planned. The following need to be taken into account to determine whether it was indeed premeditated. According to the accused, he spoke to Chanel on the 23rd day of May 2018 and arranged to meet her on the 25th of May 2018. If this was indeed the case, one would have expected that he would be very excited and anxious about their possible reconciliation, and that he wanted to get to Chanel as quickly or as soon as possible. This, however, did not happen. In his statement to Colonel Coughlin, he stated that he left Lona, where his father's farm is situated, at approximately 2000 hours and went to Vryburg. He visited his friend Jacques Viljoen and spent some time with him. Thereafter, he went to another friend, Piet Wenzel, whom he collected, and went to the veld near the nature reserve to smoke and chatted. At about 2200 hours 15, he dropped off Piet and drove to the Caltex garage. Only thereafter did he travel to Stella. It is quite obvious that he was in no hurry to meet Chanel and to speak to her about their reconciliation. When he arrived in Stella, he did not drive to the hostel, but instead drove to the Beesfees terrein. There he parked his van and sat and smoked, once again proving that he was not in a hurry to get to Chanel. After smoking, he then phoned Chanel after midnight. The phone record shows that it was 9 minutes after 1 a.m. He left the van parked at the Beesfees terrein and went on foot to the hostel. This seems very suspicious. It is, however, quite different from his evidence in chief in this court, because he testified that he called Chanel and she joined him, and they sat in his van and even ended up being intimate. The fact that he was in no hurry to get to Chanel was because he wanted to get to her after the hostel parents and other students were asleep, so that he could execute his plan to kill Chanel. According to his evidence, he parted ways with Chanel around 3:30 on the morning of the 26th of May 2018. Captain Botha testified that the phone of the accused was last active in Stella at 3:26 a.m. This by no means serves as proof that he left Stella at 3:26 a.m. It simply means that the phone was still active at that time in Stella. The next activity on the phone of the accused was at 5:01 a.m. in Vryburg. The accused most probably have been in Stella between 3:26 and 5:01 a.m. This fits in with the time that the photo and message was sent to Ronnie Hough at 3:45 and 4:20 a.m. respectively. Stella and Vryburg are 47 kilometers apart and can be traveled in 20 minutes depending on the speed traveled. The last activity in the form of a phone call or attempt thereto between the phone of the accused and that of Chanel was on the morning of the 26th day of May 2018 at 2:38:03, which didn't even lasted 1 second. Thereafter, the accused did not call the phone of Chanel, bearing in mind that he arrived at his mother's place at 4 a.m., slept for a while, woke up, and then drove to his father's farm, approximately 140 kilometers far. He made no phone call to his lover Chanel, with whom he just reconciled and were even intimate hours before. En route to his father's farm, he didn't call Chanel until, according to him, he was called by Lynn Marie Hough and informed about Chanel's death. This is indeed very strange behavior of a man who loved his girlfriend very much. He made no effort to call her and find out how she slept the previous evening. Very strange indeed. He must have known, and I find that he indeed knew, that Chanel is dead. That is why he didn't bother to call her again. It is indeed highly probable, as submitted by Mr. Smith, SC, on behalf of the state, that the accused saw the Volvo truck in Vryburg at 4:41 a.m., as testified to by Mr. Dupree. However, after committing the murders, he traveled to Vryburg, and no mention is made about the truck in any of his statements. This must have been an afterthought. Having established that this particular Volvo truck left the farm at 4:22 a.m. that morning, he mended his evidence to fit in with this time in an attempt to exonerate him, and in particular to get away from the time that the message and the photo was sent from Chanel's phone to her father, Ronnie Hough's phone. He stated in his statement to Colonel Coughlin that he arrived at his mother's place around 5 a.m. Once again, this is totally reconcilable with the times testified to by Mr. Dupree. As alluded to earlier on in this judgment, the accused's testimony cannot be believed in its totality. He contradicted himself on numerous occasions. This much was also correctly conceded to by Advocate Nell, who appears on behalf of the accused. Furthermore, his evidence is also riddled with improbabilities. Again, as correctly conceded by Advocate Nell. This court has no hesitation whatsoever to reject the evidence of the accused insofar as it differs from that of the state witnesses. This court finds the state witnesses who testified in the main trial to be truthful, honest, and reliable, and this court therefore accepts their evidence. It is clear from the evidence presented as a whole that it is the accused who murdered the two deceased, Chanel and Marna, and not Brandon Victor, as he wanted this court to believe. This court finds that the accused planned the murder of Chanel. He called Anastasia and informed him about his unhappiness with Chanel. This was done on the 24th of May 2018. He told Anastasia that he will cause Chanel to commit suicide. This is precisely how he executed his plan. By hanging Chanel, he wanted to create the impression that she committed suicide. He whiled away time by visiting his friends Jacques and Piet in Vryburg, so that he could arrive at Stella in the wee hours of the morning. By then, everybody would be asleep. He knew how to gain entry to the hostel, as he was previously also a student there. This much he told Chanel in his conversation with her that was overheard and as testified to by Brandon. He went into the hostel after Brandon had left and went to sleep. He accosted Marna in the bathroom and throttled her with a sling or strap of the handbag, which he found underneath the staircase. He left Marna's body in the bathroom and did not tell Chanel about it. He thereafter throttled and hanged Chanel on the railings of the staircase to create the impression that Chanel had committed suicide. This was indeed what he told Anastasia. He first killed Marna and left her body in the bathroom. He could not hang Marna at the railings of the staircase to also create the impression that she too committed suicide, because Chanel would have seen it. I find that the accused indeed premeditated and pre-planned the murder of Chanel and had a direct intent to kill her. The same cannot be said about Marna. He was told by Chanel that Marna does not and would not approve of the reconciliation and continuation of their love relationship, and that he must first sort things out with Marna. As I said, this must have angered him. And as fate would have it, Marna was in the hostel. She was the only other girl in the hostel and roommate of Chanel. Lo and behold, during the temporary absence of Chanel, who went to put on her ski pants, Marna was on her way to the bathroom. This created the ideal opportunity for the accused to follow Marna to the bathroom, accosted her, and throttled her, and left her body in the bathroom. The accused by no means could have foreseen or knew beforehand that Chanel would tell him that Marna does not and would not approve of the reconciliation and continuation of their love relationship. It happened when he conversed with Chanel that evening. This court finds that the murder of Marna was not premeditated or pre-planned. The accused decided there and then that he should kill Marna and formed the intention to do so at that moment in time. There was no prior planning, as was the case with Chanel. Can the accused please stand? This court is satisfied that the state succeeded in proving beyond any reasonable doubt that the accused murdered Chanel Hoog and Marna Hoog by throttling them and also hanging Chanel Hoog. The accused is therefore found guilty as charged on both counts.
And the complete minority.
The accused does not plead this conviction.
Mr. Nell?
My Lord, can I ask for a short adjournment that I can just discuss it with the accused and just get instructions from him?
The court will adjourn.
All right. for reports? No, they will call Judge Akere. They're still discussing something. Yeah. I don't know how long they're gonna take it. Huh? Yeah.
feedback from family.
Yes, Mr. Nell?
Thank you, court, my lord. During the adjournment, I had discussions with the accused, and it's my instructions to request for a pre-sentence report from a probation officer of the Department of Social Work and Development. I had discussions with my learned colleague and his junior advocate from Wake to hear how can be arranged for such a report if my lord grants us a postponement to get such a report. I'm not sure exactly how long it takes here. I know in Northern Cape we are struggling a lot to get the reports in time. Most of the time they just bring the reports to the court on the court day, and then it's very difficult to proceed without consulting with the accused with that report. So what I want to submit, the matter is put down for 2 days, for today and tomorrow, that we roll the matter over till tomorrow. And then in the meantime, myself and my learned colleagues will have discussions, and we will have discussions with the social department to see what they need and how long it will take for such a report. That if it's necessary, we can ask my lord tomorrow to make an order for such a report, and that he can put specific dates to when the report must be available and available to myself and to my learned colleagues. So my request is a postponement for tomorrow, so that we can try and sort this out, and then ask for the demand and for the report tomorrow.
Mr. Smith?
I have no objection, my lord.
Yes.
My lord,
Mm.
there's one issue that I wish to put on record. After the court adjourned just now, Mr. Monty Belsma, father of the accused, assaulted the investigating officer, Captain Ferreira, by hitting him with a fist in his face. He also threatened in my presence Mr. Chris Saunders by pointing him and saying, "Ek kom weer, ek kom weer." He also threatened Colonel Coughlin in the same manner. I requested my learned friend to speak to his client, Mr. Belsma, Mr. Monty Belsma, to inform him that I'm aware of that conduct, and that he must please refrain from doing so in any manner in future. I just wish the court to confirm my request to Mr. Nell with him. And I just wanted to appear on record so that nobody can ever say that nothing was said.
But, Mr. Smith, you know, people have rights. And those affected can do what is necessary.
My request to Mr. Nell was please inform your client to stay away from the people who testified and from the investigating officer. All I want from this court is to confirm my request to Mr. Nell. So Mr. Nell can just confirm that was my request.
Thank you, court, my lord. Yes, I'll indeed follow it up, and I will indeed have discussions with Mr. Monty Belsma. I haven't got personal knowledge of what incident happened, but I will definitely discuss it with him and advise him accordingly.
Yes, thank you. Mr. Belsma, please stand. Zander Belsma. This matter is remanded until tomorrow morning. That is the 18th day of February 2020. At 10 o'clock, you will remain in custody until then. The reason for the postponement is to allow your counsel as well as the state the opportunity to make arrangements for a pre-sentence report. Do you understand? Yes, thank you. Court will now adjourn.
All right.
Opiki? We have another matter. There was, Moses was here, he was asking.
Who's Moses?
From Legal Aid.
Oh,
He was
Sebastian.
asking if we are free, we have a matter with him, what time it's going to start.
hij moet met lastigheid komen. Hij komt met lastigheid, ik zie nog.
What happened to the matter?
Hm?
What happened to the matter? And that parcel there is for you next. That plastic.
Ja.